All right, well, the podium is on, but we don't have a court reporter. Do we need a court reporter for Ms. Hamilton? Okay, why don't we dive in?
Yes.
Okay. Deputy Gordon, you want to bring Ms. Hamilton out? Please.
Yes.
Hello, Ms. Hamilton.
How you doing?
I wish I was seeing you in a different context, but here we are. So your two cases, and is there another or it's just two?
There's actually 4 total.
4 total.
There's 3 indicted and 1 unindicted that Ms. Hollander was here for, I believe.
Got it. And it's the unindicted that is what got Ms. Hamilton arrested most recently?
Yes.
Okay. For whatever reason, we have 2 of the indicted cases on here. And Ms. Hamilton, we're just trying to figure out where we're going next. You and I worked together when you were in drug court. That went where it went. Then you picked up these new charges. Do you know what those charges are? Not meaning, I'm sorry. Oh, it's criminal damage. That's right. That's right. Someone mentioned that to me. So we need to figure out what the next steps are. Are all 3 cases in this division, or do we need to grab number 3?
I'm gonna double check. I think we might have to grab number 3. And Judge, I was thinking it would make the most sense if I did waivers on the cases.
Mhm.
And I was explaining that to Ms. Hamilton. And she's very eager to move on with her life. And so that was what I was hoping that you could help explain.
Sure. So let me talk process, and then it'll be your turn to share with me what's bugging you beyond you want to move on with your life and not be sitting in jail. You have 3 indicted cases. I think they were all in drug court. I know at least 2 of them were. You were terminated from drug court. We had the conversation about whether you wanted your cases to go back to whatever court they had been in originally, or the default is that they would go here. And your cases were all what we call diversionary cases. So if you had successfully completed drug court, they would have been dismissed. But that's not how it played out. And so we are working through what the next steps are. You'll need to talk with Ms. Wood about, trying to find what judge, Judge Whitaker. All right, so your cases were with Judge Whitaker. She sent you to drug court. That didn't work, so you're here. And the way this will flow, have you had cases in court before, or is this your first? No, it's not your first time in court, but were these your first cases that got you into Superior Court?
Yes.
Okay. Because I didn't want to tell you stuff you already knew. The way this will play out is that Ms. Wood is going to file what's called a waiver of arraignment. That's just, she's saying not guilty on your part. That will trigger the state's obligation to get to Ms. Wood and thus ultimately to you all the discovery in the cases. That's police reports, if there's body cam video, whatever the state has that they would use to prove that you did these things that you're charged with. You've got one case where it's family violence battery, and to me, it looks like it's all misdemeanors, but either way, it involves you having some kind of altercation allegedly with someone else. Another case is obstruction of law enforcement officers. So you had some interaction with the police and they said it went a certain way. The third one is the one not on the calendars.
Aggravated assault.
Okay, aggravated assault. And then we've got these new charges that we can bring together if you're going to resolve everything. But you and your lawyer need to look at all the evidence, because it may be that there's not much evidence, which gives your lawyer a better bargaining position to say, come on, state, let's get Ms. Hamilton on her way. It may be that the evidence is not good for you, and I'm making this up, but there could be a video of you hitting someone on the head with a baseball bat. That's not real helpful for you, and the state might not be interested in saying, let's just forget about this and get Ms. Hamilton on her way. I don't know what that evidence is, but you and Ms. Wood will talk about that, and she'll give you her thoughts about how you and she ought to try to work the cases out. Plus, she may see in the evidence things where the police didn't do their job the right way, and she could file a motion to say, Judge, you have to keep this out. They tricked Ms. Hamilton into confessing, and they didn't read her rights or whatever. And I'm not saying that happened either, but these things can happen. All that means that Ms. Wood needs a chance to look at that discovery and to talk with you about the discovery to come up with a plan. The plan isn't simply, let's forget about this. So she's going to work with you, and then she will get back to me, and she'll get back to the prosecutor about what's happening next. And I will see you soon, either because there's a motion that we need to argue about, or because you and Ms. Wood have decided we're going to work this out, and maybe you've worked something out with the prosecutor, and then we take a plea. Or you may say, I don't care what they offer me. I'm going to trial. I didn't do this stuff, and I'm not going to admit to it. And so let's have a jury figure it out. We, in the end, do the one you pick, but Ms. Wood may be giving you advice as to, hey, we should go this way rather than that way. None of that happens today. What happens today is these entries of a plea of not guilty. That's the waiving arraignment. And that starts the wheels turning. The prosecutor's going to get discovery to your lawyer, and we go from there. Now, I just laid a lot on you. Do you have questions about any of that?
No, I mean, when the aggravated assault happened, that was, I said 14 months until that case was indicted. Like, literally, I have not been home. Like, I haven't been home. I've been in and out, in and out.
You're right. And you were not in drug court very long because of the stuff you were struggling with.
It wasn't dealt with then. It's starting to become aggravating. It's irritating because, like, at this point, like, just.
You're ready to be done with it.
Yeah.
Yeah, I hear you.
I don't understand why I wasn't offered, I don't understand, like, why I wasn't offered probation or, felony probation.
Okay.
I don't understand, like.
So that may well be what you're offered now. Originally, the goal was to get you treatment. That didn't work out, but.
I feel like I'm not an addict, sir.
Okay. Well, and you and I don't have to go around on this too much, but you told me several times, because you were real honest with me, that you drink too much and you're going to, doesn't matter what we say, you're going to keep drinking. And so I don't care what label we put on it. It was clear that you and alcohol had a bad relationship.
Which I don't need it. So.
Okay. Well, maybe.
I made up in my mind that I don't want to drink anymore.
Yep. Good. That is a great term.
Going through all of this, I don't want to drink.
Because it ain't worth it.
It's not.
Right.
Not to go through all of this, no.
So two things. One, that's very healthy, and that's something that you're going to want to build on. Two, all this time that you've been stuck in jail in connection with these cases, you get credit for all that. So, and I'm making this up, but let's say the state were to say, you know what, Ms. Hamilton doesn't seem like a dangerous person, but she keeps getting in these issues. She probably needs to be away from the person in this case because that person's a little scared of her. We're going to offer her 5 years to serve 1 year balanced probated. If you've already done that 1 year, you don't do it again. So I don't know what the state's going to offer. It's a very reasonable set of prosecutors. They're going to talk with Ms. Wood about it, and she'll talk with you about it. But you have already served a bunch of time, and you'll get credit for all that. We don't do redos here, okay? My request of you, and it's just a request, it's not an order, is that you work with Ms. Wood when she gets that discovery and says, let's sit down and look at it. Just be honest with her about it and say, yeah, that's what happened, or here's, no, that's not the full story. Let me tell you more about it. And you can be frustrated. Don't be frustrated with her. She's simply bringing you the evidence that the state has. And then the more you can work with her, the sooner she can say, I think we can work this out. And I'm ready to do that whenever. I'll move this quickly because you have been stuck for a while and you're going to stay stuck till we work this out. But I'm happy to move it along. We got to figure out what's going on with that fourth case, the one that's not indicted. That will not slow things down, but we still got to figure out what we're going to do with it. And I'll see you either because there's a motion, like I said, Ms. Wood's trying to keep something out if it goes to trial, or because you and Ms. Wood, and she has a colleague named Ms. Ross, who may come talk to you. Ms. Ross is real good at finding folks opportunities on the outside. You may already have a place to stay, but if you don't, she's good at helping find housing, programs, things like that. Something that makes me a little more comfortable that when you get out, you're not just going to be on your own and maybe slipping back into doing some of the things you did before that got you in trouble. So that's where we are. I hear you and feel you that you're frustrated. You've been in for a while. You get credit for all that, but you need to let Ms. Wood do her work on your behalf. And I'll tell you, if we go a few months and Ms. Wood hasn't done anything, you bring that to me, and then I could be frustrated with you at Ms. Wood. Okay? All right, Ms. Wood, anything else in connection with Ms. Hamilton?
No, Your Honor, I'll get the waivers filed today.
Okay, Ms. Dilligard, in looking at these charges, they may not be yours. Are they going to be more Ms. Charles's cases, or at least you'll start with them to get discovery moving?
Yes, Judge.
Great. Okay. If either of you run into any delays, let me know because I am anxious to have Ms. Hamilton's cases move along. Okay?
Yes, Judge.
Ms. Hamilton, I promise you, you could ask me questions after I was done talking, and I'm done. Do you have questions about anything I said?
Oh, not really, Judge. I do want to apologize for wasting you guys' time with the drug court. I came to my conclusion that I'm not an addict, sir.
Okay. And I'm going to respect that designation. You are not an addict. You don't need to apologize. I mean, you saw you're paying the consequences, not me. But I will see you soon and we will figure out what you're going to do for the next chapter of your life. Okay? All right.
Thank you, Judge.
You're welcome. Ms. Wood, you'll do a waiver in all three cases? Thank you. All right, do we want to do Mr. Leech now? And I think Zoom is really up and running. We've got Ms. Rivers and others, so that was fine that we handled that thing. That didn't need to be on the record. All right. Why was Ms. Hollander here? Because criminal damage to property doesn't seem like a specialized unit kind of case.
It's against an older person.
Okay.
I think it was the original charges. I don't think it got indicted that way, but
Okay, but it hit her radar because of the elderly connection.
yes, Judge.
Was it a relative or a stranger? Okay. Okay. All right. Got it. But that's the kind of case that can go to you once it's charged.
Yes, Judge.
Okay. All right. Well, that may be it for you two.
Yes.
Mr. Leech, welcome back.
How you doing, Mr. McBurney?
Ooh, about the same as last time.
That's good, young.
How about you?
I'm doing all right.
Good. Well, I think your ship came in terms of getting into the program.
Okay.
I mean, Hope House, that's what we talked about, but I think there's a bed ready. I'm going to let Ms. Rios remind me where we left off and what we're doing to move forward.
Yes, Your Honor. Last time we reset because I didn't have the official acceptance letter from Hope House. I have got that, and they gave a date for when he should be transported, and so I sent the transporter to you. I know the state was recommending, not the state, probation wanted to revoke 1 year. He has done continuous custody in 1 year. I sent an email kind of piecing together, like it initially was in Rice Street, March, and then he went from March to June, went to Gwinnett.
Oh, right, we talked about this, like there are 106 days here last year, and then you're saying he was transferred to another agency, which was, so he didn't get out.
No, and so that's what the email I sent had the Gwinnett proof of incarceration, and I took a screenshot of the DOC website would prove that he was then in DOC. So continuous 1 year. So since they don't get
You did take a picture of the screen, okay.
So I know that they don't get credit for probation revocations if it's above 6 months. So I'm asking, that's right? Above 6 months.
So if Mr. Leech is revoked for more than 6 months, that is a case that the sheriff will send to GDC, and GDC will not give Mr. Leech any credit for time served.
So I'm asking for 6 months then, since totally he's been in for continuous for a year, and then credit for that time that he's been in from that date of March 6, 2024, and let him go to the Hope House program where he'll get all the treatment for his mental health. He's bipolar, and is homeless, and they are going to work with him to find housing and address his mental health and therapy and all the good stuff that Hope House does.
Okay. The only thing I'm not finding is, the transport order was part of this thing with the screenshot. There it is. So I've got everything. Let me see. The transport order says a week from Thursday.
Yes.
Okay, got it. Along with medication. I think I understand that. I think what I don't have anymore is the warrant. Remind me what Mr. Leech was being revoked for.
He was being revoked for. It was two things, it looked like.
Yeah, I think it's a new offense
Yeah.
that is indicted in Judge Krause's courtroom, and then also failed to submit mental health evaluation and failed to report.
Okay, I'm remembering now. And this is the one where, for whatever reason, your office cannot handle the Judge Krause case. There's a conflict, which is why we're not wrapping it all together. But Mr. Leech has made bond for the Judge Krause case.
Yes, my understanding is that's not holding him in.
Okay, got it. Okay. Your recommendation, Ms. Dilligard, was to revoke a year.
Yes, Judge. And
All
I
right.
also want to just remind the court that Mr. Leech has had 2 prior revocations.
Okay. And how much time, Ms. Simpson, remains on this 17 SC case?
He has 3 years, 8 months, 20 days.
All right. And is this the only case for which he's on probation right now? Got it. So, Mr. Leech, if we resolve things today in a way that gets you to Hope House, you need to understand you still have an open case in front of Judge Krause, same building. You've got a lawyer. It's not Ms. Rios. You're gonna need to deal with that. And you may end up pleading guilty and get more probation. But I don't want you to think that what we do today is resolving that other case.
Okay.
It's a separate situation.
Yes, sir.
Okay. Do you have any questions about what we've been discussing?
No, sir.
Hope House is residential, but it is not a place with locked doors on the outside,
Yes,
by
sir.
which I mean you could walk away if you decide you want to walk away.
No, sir.
I'm glad you're shaking your head. I want you to hear me now. If we are together again in a few months because you quit Hope House or they kicked you out because of something that was going on, I will probably revoke the rest of your probation and say, we just need to get Mr. Leech into a, safe is the wrong word, but if you are in custody, you're not gonna be able to get at a lot of what you may be getting at when you're not in custody. So this is your last best chance. I know you've told me you want it. And those are good words to hear, but more important is what you do when you get to Hope House.
Yes, sir.
And that needs to be a program. It will embrace you. You need to embrace it back. Make it a two-way hug. Folks get kicked out of Hope House. It's doable, and people can walk away from it. If either of those happens, and I hear back from probation, you know what, he's not at Hope House anymore. That will likely result in the revocation of the balance of your probation.
Yes, sir.
Okay, which is going to be almost 3 years worth.
Yes, sir.
Any questions about that?
No, sir.
Okay. And I'm not saying that to be threatening. That's not the way I do these things. I just want to be very matter of fact about it, that as Ms. Dilligard pointed out, or Ms. Simpson, or both, you've had some struggles on probation before, and a request to revoke more time kind of fits, but you seem to be in a place where you're ready to try something different.
Yes, sir.
I could be wrong, and if I'm wrong and you aren't, then we'll be back together, and it will be a short hearing because I've already told you what I'm going to do. Okay.
Yes, sir. Yes, sir.
All right. Then I do find, Mr. Leech, that you violated the terms of your probation and conditions of your probation by being arrested for and indicted for a new felony offense, the case with Judge Krause, along with the other violations that were mentioned. And as a result of that, I am going to revoke we have the same situation here as we do with the other gentleman. In some ways, it doesn't matter. I mean, it does matter in terms of what we shave off his remaining balance, whether I say 6 months or a year. I don't want Mr. Leech being released tomorrow, because if we do the math, he's done more than a year. He needs to stay exactly where he is until the 20th, when that transport order will occur. So what do you suggest, Ms. Simpson? Should I not sign the revocation order until closer in time, or what? Because if I followed Ms. Rios's suggestion, which is revoke 6 months, we don't have to worry about DOC and the credit for time served. If I'm the sheriff, I'm gonna release him because he's done more than 6 months.
That would probably be the better choice to hold up until next week.
Okay. Yeah, because it's next Thursday. So sort of like we're doing this week with the gentleman we were handling this morning, that maybe tomorrow or the next day I sign it. Oh, I hope I didn't just sign that. Was that Ruben Rainey?
I submitted it, but I don't know if you signed
Oh,
it.
I did, and I sent it to Ms. Nelson. So Ms. Nelson, don't do anything with that Ruben Rainey thing. I just trying to be efficient.
It's too late. Let me see if I can catch it.
Okay, call 911. I'll try to remember not to sign Mr. Leach's too early. Maybe you could put in the email, Judge, don't sign this till next week. Thank you. Mr. Leach, that just means we just want to sign this so that you don't get released early. Because if you get released to the street, that makes it more complicated for you. It's better if folks if the sheriff can deliver you to Hope House.
I understand, sir.
All right. That doesn't change the date. It's still next Thursday. The 20th is when they are waiting for you. They'll be ready to see you. We're just going to try to make that happen.
Okay.
All right.
Yes, sir.
Ms. Dilligard, anything else from the state?
Nothing further, Judge.
Ms. Rios?
No, Your Honor.
All right. That's it.
Thank you, sir. Thank you, man.
All right. We have the presiding bond calendar that had 5 positions on it, but we're now down to 3. First up was going to be Mr. Anfield, but his lawyer and the prosecutor stepped out. So Ms. Reimer, we can go to Mr. Brown if we've got a lawyer for Mr. Brown here. We do.
Your Honor, Attorney Nasada, Public Defender's Office.
Good to see you again. How you doing?
Doing well.
Are you ready to go forward with Mr. Brown? I know we're in this dynamic and we're trying to fix it, but we are putting on the calendar everything that got a bond deferral, and sometimes the lawyer hasn't even asked for a bond yet. In fact, one of the ones that got pulled off, one of your colleagues reached out to say, I want to do the prelim first. And you come back to me either way. I have these cases for bond until indicted. I'm not trying to talk you out of doing bond. I just want to let you know, we haven't fixed it yet. We just grabbed everything that had a bond deferral and put it on here. And really it needs to be one more step, which is to reach out to the defense attorney saying, are you ready for this week or do you want it later?
Yes, Judge, and I've discussed with Mr. Brown, we're ready for bond.
Okay. Have him come on out.
Podium.
Sure. Give me 1 second. Get this started. Hey there. You. Just pulling up your case, Mr. Brown, and then we'll get going. All right. Ms. Rivers, you ready to go?
Yes, I am.
Great. All right. This is 25 PI 001365, State versus Richard Brown. Mr. Brown is here in court with his lawyer. We have Ms. Reimer here on behalf of the state. Mr. Brown, I'm Judge McBurney, and your case has been assigned to me for purposes of bond only. Your case is not indicted yet. If it is indicted, it'll be randomly assigned to one of 15 judges. I'm one of them, so I might have it after indictment, but that would just be a coincidence. But as long as your case is unindicted and there are issues with bond, questions about bond, you and your lawyer and I and the prosecutor will be working through that. Today, I'm going to hear from your lawyer about whether I should set a bond. He's going to say yes, and what that bond should look like. And then I'll hear from Ms. Reimer to get the state's perspective, and we'll go from there. Okay? I'll take that as an okay.
Yes.
All right. We're ready.
Yes, sir.
Thank you, Your Honor. Mr. Brown is 27 years old and a lifelong resident of the state of Georgia. He's been in custody now at the Fulton County Jail for about 2 weeks, but he is come to Rice Street after spending the past 2 years in DOC custody, serving for another case, Your Honor. And so he has, I think, a couple of FTAs. Those are related to his time in custody. This should be cleared up once he has a court date to address those matters, Your Honor. All of his family is located here locally in Georgia. He has his family here today in the courtroom to show their support for him. He's been employed prior to his arrest 2 years ago. He was working for Quality Control, the record label, and was doing well working there for about 6 years prior to his arrest. He's a high school graduate and is enrolled at Georgia State, but still about 4 years away from earning his degree in studio engineering and film, in addition to nursing, Your Honor. He's a father to 4 children who he provides for financially, including a 1-year-old who was born while he was in DOC custody and has not had the pleasure of spending face-to-face time with without a screen in between or supervision like that, Your Honor. Mr. Brown previously has been out on pretrial supervision with an ankle monitor on a theft by taking, Your Honor, and had absolutely no problems complying under all the conditions that pretrial required him to comply with, Your Honor. And we don't believe he's any sort of flight risk. He has strong connections here to the community, and as well believes strongly in his innocence and wants to stay here and fight the case, Your Honor. He is, as I said, been in custody since 2023. While in DOC custody, he underwent, or consented to rather, a search of his person and gave a buccal swab, Your Honor. And so we're assuming there's some kind of DNA evidence possibly coming down the line with this case. And if that was the case, Your Honor, we would hope that there would be an indictment already, given the age of this case. The case has still not been indicted. Mr. Brown is here waiting on no bond, which we believe he deserves to be given at this time, Your Honor. We'd be asking for a total bond here not to exceed $100,000 from Mr. Brown.
Help me think through a bond of that size and the fact that you're representing Mr. Brown. And I think I may have read something prepping for this about a Rolls Royce and this and that. I just want to make sure he's not taking advantage of your services.
No, Your Honor, there may have been a time prior to his arrest where he would not have qualified for public defender services, but he's been incarcerated for the past 2 years, has not earned any money in that time. That job may still be available for him going forward, but I'm not sure whether Mr. Brown had savings or not, but at this point he does qualify. He is indigent, Your Honor, and qualifies for public defender services. And there was, a Rolls Royce mentioned in the warrant, Your Honor, and it's not clear whether he owned the Rolls Royce or whether it's part of a thing, to work for a record label and to show out for people that you're trying to sign to your record label that, the things that a record label could offer a young aspiring artist.
It is all about rep. I hear you. Tell me why Mr. Brown was in DOC custody for 2 years.
Yeah, answer.
Either one of you.
Okay. I was in Clayton County for 2 years. That I got sentenced during the end of my second term of the year. I was already had probation violation out of Douglas County, and my probation officer agreed to reinstate me. So I ended up taking a plea. And then the last 2 months I was sent to DOC, which was Central State Prison. And I was released there to come here.
Okay.
For my case.
So I didn't ask the question. I appreciate that. That's helpful detail. What kind of charges had you in custody for 2 years, whether it was in Clayton or Central State or?
I had an aggravated assault.
Okay. And it's the aggravated assault that resulted in all that time in Clayton plus a few months in Central.
Yes, sir.
When aggravated assault can mean a lot of stuff. I could wave a stick near you and that's an aggravated assault. You could shoot me in the leg. As long as I don't die, that's an aggravated assault. What kind of aggravated assault was this that took 2 years of your life?
I had an aggravated assault with a deadly weapon. At first, I had a firearm charge. They dismissed the firearm charge, and they only charged me with an aggravated assault. The aggravated assault was, they were saying that something was happening in the midst of a crime, like something happened, and it just wasn't no gun. It just was, I guess that's how they charged me with it. It said ag. Nobody got hurt, though.
But it wasn't that anyone got shot?
No, nobody got shot. Nobody got hurt.
Got it. So ag assault. You mentioned a bunch of counties. You also have charges out of Douglas County?
No, I have probation and already handled it. Once I get there, I'll be reinstated on probation.
And what were the charges out of Douglas County?
Just a possession of firearm by
a felon? What's the felony behind that?
It was just possession of firearm by a convicted felon.
Right, but in order for you to be in trouble for that, you have to have been a convicted felon. So what's your even older conviction?
In 2019, I was convicted of assault out of California. I was living in California and I had a fight and I got charged for the fight and they charged me with assault.
And it was a felony?
Yes,
the
sir.
one in California?
Yes, sir.
Where in California?
It was in San Francisco.
Okay. All right. That's all I got, I think, for right now. The case you were on an ankle, I'm not quite done. Your lawyer, well, either one of you can answer this. He was on ankle monitor for something, but I haven't heard about that case either. Is that?
They dismissed the case here. They dismissed it. I was like 17. I was here and they put me on pretrial bond for $10,000. I was on bond for 7 years and I had no trouble at all.
Did you have an ankle monitor for 7 years?
Oh, no, they took the ankle monitor off the first year I completed. They said if I comply with pretrial, they would take it off. They took it off and they dismissed my case.
Got it.
Because I comply with it. So,
all right. Got it. Ms. Reimer.
Thank you, Your Honor. The state would be asking that Your Honor holds the defendant no bond. Just looking at his history, he has mentioned some of the violations and the history that I was going to also mention. However, looking at the dates of everything, this case specifically, he's a 2022 case in front of Judge Barwick, which is on a judicial hold because he was in Georgia State Prison. That occurred on 7/15/21. He also has a DeKalb County case, which he is on a county hold on right now. That date of incident is a 12/10/22. And then our case is a January 20th, 2023. And all of the charges are similar in nature. The case in front of Judge Barwick is an aggravated sodomy, aggravated assault, 3 counts of that, false imprisonment, a theft by taking, identification fraud, possession of firearm during a felony.
What's
battery.
the case number for the Judge Barwick case?
22 SC 185064.
Okay, you can keep going.
Yes, Your Honor. He also has another case pending in Fulton County, also on judicial hold, 19 SC 164494. That's a non-complex case of theft by receiving. Again, those had failures to appear because he was in Georgia State Prison. One of his cases, though, does have a failure to appear because he was in California in another jurisdiction committing crimes. The case that he was convicted on, he also was arrested on, again, similar types of charges that were eventually not prosecuted by the state of California, but again, similar types of charges to what we have here, which included sex with an under 18-year-old, as well as sending obscene materials to a minor. The state is very concerned about the defendant's history and his pending cases and the facts of the case. We believe that he does have a risk of fleeing the jurisdiction based on his history of committing crimes in multiple counties and states, and his violations of probation. The threat of danger to the community, these are involving children. One of the children specifically in this case, he used the guise of a play date with his child in order to get her in his custody, for lack of a better word. And we believe that's a huge threat to the community and for the safety of the community and others within the community. The risk of committing a felony, I've already gone through the cases he currently has and the dates, and he has just continued to commit felonies while he's been out of custody. And again, these are children involved in these cases. He knows the family, knew the family, at least in one of them. We do believe there is a possibility he could threaten the children, threaten the families, intimidate them to not go ahead and go forward with the case, especially. I don't know the circumstances as why the California case was dropped, but it does lend to something like that. The state would be asking that you hold him no bond pending, I guess, a determination on a pretrial hearing.
Got it. Okay. The case with Judge Barwick doesn't look like it involves a minor. It may have been a young adult, but there aren't any child-related allegations there unless I'm missing it.
I had a cruelty to children in 3rd degree.
Oh, okay, fair enough. That's in there, but the actual aggravated sodomy allegation, what?
It's not involving a child, but it is one of the 7 deadly.
It is? No question about that. I just want to make sure I wasn't misreading something in there.
Yes, Your Honor.
Okay, got it. Appreciate that. Always gives the last word to the movant. You didn't mention the Judge Barwick case. That's kind of problematic. And then if there's a DeKalb hold, maybe we should sort that out before we worry about this situation.
Your Honor, it's my understanding that what's going on with DeKalb is related to the same incident. It's I'm not sure which county is going to have jurisdiction in the end, but
meaning the incident for which we're together, the alleged January 2023.
Yes, Your Honor, that's
Okay.
correct. So we're not sure at this time whether that's going to go forward in DeKalb or here in Fulton County, but it is for the same alleged act.
Okay, and he ought not to have to ping pong between the two if it's all connected.
Yes, Your Honor.
Got it.
And I apologize for not mentioning the case with Judge Barwick that is presently in judicial hold. We would just state again that there are, charges for aggravated sodomy. It's not alleged to be against the child, but still that Mr. Brown is innocent until proven guilty. And as what happened with the California case where the charges ended up being dropped, we are confident that will happen again here with the case with Judge Barwick. But Mr. Brown doesn't have a history of this kind of thing. He has possibly a history of being charged with this kind of thing, and it also has a history of those charges being dropped and not being convicted or found guilty of any of those acts. So we would just again reiterate our ask that Mr. Brown receive a bond today not to exceed $100,000.
Got it. All right. Thank you. Ms. Reimer, a quick question. Pronounce your last name again.
Mirsajidin.
Mirsajidin. Mr. Mirsajidin, had raised the question that I has as well, which is this is an old set of allegations. And yes, Mr. Brown was elsewhere for a while, but that doesn't mean the state couldn't have gone forward. Is there any reason to think there won't be an indictment soon in this case? Was there something that held up getting the warrants in this case?
Unfortunately, Your Honor, I do not know. I can find out the time limit or timeline for the indictment. Looking at the information that I have, which is the warrant and the probable cause, I don't see anything that would, I don't know, but I only have one report right now.
Okay, that's all right. I mean, it doesn't change what I'm going to do today. It changes how things may flow for Mr. Brown.
Yeah, sure.
So it's just helpful to know. Okay.
I also just have one point of correction. The DeKalb case is not the same victim, not the same date, not the same vehicles as our case.
Okay, thank you. That's good clarification. Doesn't change what I'm going to do. Gives me more resolve for what I'm going to do, though. So, Mr. Brown, a few things. I need to correct one thing I mentioned, which was your case will be randomly assigned to one of the 15 judges. It won't. It'll go to Judge Barwick because you already have an open case with Judge Barwick. So should this case get indicted, I don't know if it will, but if it is, that goes to Judge Barwick as well. We try to have one defendant, one judge. And so your non-complex case will move over there as well. So I've got too much on paper to be comfortable setting a bond in your case. I don't disagree with Mr. Mirsajidin that these are all allegations. That's not proof of anything, but it's a whole lot of smoke surrounding you with some pretty scary sounding charges. And rather than running the risk of you being either wrongly charged again in the next few months if you get out, or rightly charged again in the next few months and we've got another victim, I'm gonna keep you where you are. You will have your case in Judge Barwick reactivated real soon because, in fact, you're on for plea and arraignment in front of Judge Barwick in just a few weeks for that older case. You will meet your lawyer in there. It will not be Mr. Mirsajidin. It will be a colleague of his, and that lawyer can help you navigate the rest of this. But this case is going to need to catch up to that one. It's a collection of pretty serious charges, and in my mind, we're done messing around with bond. It may be that your lawyer, whether it's Mr. Mirsajidin or the person in Judge Barwick, petitions me to do something with this case so that you can get over to DeKalb, like lift the hold and put the hold back on. But that's a strategic discussion for you and the lawyer to have if you want to see what's going on over in DeKalb. But for now, in Fulton, you are going to stay put, and you will see Judge Barwick in just a few weeks anyway. Not on this case, but on the older one. But when this case, should it get indicted, it'll go to that very same judge, and you'll have the same lawyer supporting you. Okay? Thank you. Is Mr. Melnick, are you handling the Anfield case for the state?
Yes,
Mr. Melnick's back. Great. That's what we were going to do first, but you guys were talking, which was great. So we pivoted and handled one of Mr. Mirsajidin's. Do you also have Mr. Wavor?
Petrarca, Your Honor. I wanted to ask you if that was the case that had been dropped. I spoke with Mr. Petrarca or wherever Petrarca on Wednesday of last week. He told me at that time that he intended to hire a private attorney, and so I let him know that we would ask if the attorney was not ready here today for a reset for his bond hearing to hire private counsel.
Not a problem. If he's here, do you want, I don't know if he needs an interpreter.
He would need an interpreter, but I spoke with him with an interpreter at the jail and let him know that this is what would happen in the likelihood that his attorney would not be ready for hearing today.
Does he have any family here? I don't know if they're here for the victim.
I'm not sure if they're here for the victim or for Mr. Petrarca.
If there was someone who could tell him that, but it sounds like he knows if he goes away, it's not that bond was denied or granted or anything. It's that he's in between lawyers.
Yes, so I spoke and let him know that this is not his prelim. He's still scheduled for his prelim as well and all.
Got it. So we will reset it. There's not a date certain. We just, when a lawyer gets in the mix, we'll figure out what to do.
Understood. Thank you.
Okay.
Your Honor, may I be excused then?
Yes, ma'am. Hey, you're good to go with Mr. Williams the week of the 24th?
Yes, Your Honor.
Good. we have the calendar call this Thursday, and I'll ask you the same question again, and you can say the same thing again.
Yes, Your Honor.
All right.
So the April 3rd date in there's not real?
What is the April 3rd date?
There's an April 3rd trial date in the Odyssey now?
That's the next calendar.
Okay.
I asked Ms. Nelson to put things that we might not, we only have a 1-week calendar for March. And there are a couple other cases. I think the goal is to do Mr. Williams, but stranger things have happened. And in case we don't, I wanted there to be yet another date for him. And that's, so it's not a fictional date. It's just,
Sure.
yeah, if we don't get to it on the 24th, then we'll see you soon after that.
Thank you, Your Honor.
All right,
Have a good day.
you too. All right, Mr. Melnick, are you ready for Mr. Anfield?
I am.
Okay. And Mr. Hiles, you may have seen it, but I think there may be a family member of Mr. Carter's on the call as well. I mean, when we get to the point where it's appropriate, if any of the victim family members want to be heard, I just wanted you to know there's someone with the last name Carter on the call.
That's my understanding is that they were to appear by Zoom today. I just spoke with our advocate, so
Yeah.
whenever it's appropriate.
That's fine. And Zoom is fine too. I just wanted you to know it's there.
And then position 1 on the calendar, Your Honor, Mr. Oliver.
It is off.
Okay.
Ms. Clark asked for it to be, come on up to the podium, Mr. Anfield. She wanted to do the prelim first.
Okay.
So it'll be here whenever it happens, but she'll need to say, I'd like to have a hearing, and then we schedule it. So it's off.
Okay, I'll let Mr. Abate know.
Yeah, he just poked his head in, but
He was just telling me that to text him whenever they were ready.
Okay.
He's next door.
it's not happening. Per Ms. Clark, the defense attorney's request.
Okay.
You all right? You've been in jail for what did you get arrested? 30 days now. Okay. All right, let's get on the record in 25 PI 001298. It's State versus Jerry Anfield. Good afternoon, Mr. Anfield. I'm Judge McBurney, and your case has been assigned to me just for purposes of bond. If you end up getting indicted, that'll get assigned to a judge probably randomly, unless you already have an open case in front of another judge, then it will go there if it's in Fulton County. You are here with your lawyer, Mr. Melnick, who filed an entry of appearance not all that long ago. And Mr. Hiles is handling the bond motion for the state. So all we're doing is talking about bond. My ruling is not you're guilty, not guilty, or anything like that. It's just, yep, bond makes sense, or no, bond doesn't make sense. And the question of bond will stick with me until you get indicted. So I may say, I'm gonna set a bond at X, and a month from now, you're still in, you can't make that bond. Mr. Melnick may knock on the door and say, Judge, we gotta talk again. That number you set was too high. It's not realistic for Mr. Anfield and his family. I may say no bond, in which case people don't knock on the door till you get indicted, okay? Mr. Melnick, welcome back, and I'm ready to hear from you.
Thank you, Your Honor. So, Your Honor, Mr. Anfield is 18 years of age. He was enrolled in high school on the date of his arrest. He was arrested on February the 18th, or booked in February the 18th of this year. He was enrolled in Skyview High School. He lives in Fairburn with his mother, Tamara Anfield, who is present in court. If you will stand up for me, please. And his father, Xavier Jones, is present as well. You can stand up for me as well. He also has two younger siblings, ages 13 and 11, that also live at home, and that he helps his mom obviously care for. So, Your Honor, obviously you can see the nature of these charges. There's serious charges, but Mr. Anfield denies his involvement in what is alleged in the warrants, And that is a matter that we will take up as the case proceeds. It's my understanding from speaking with Mr. Hiles that there may be something in juvenile court. However, I've spoken about it with Mr. Anfield, and what he has told me is that it did not result in an adjudication of delinquency.
When you say something in juvenile court related to this, or you're referring to any,
Another case.
I'll call it criminal history, but as a juvenile, issues where he came into contact with juvenile court?
That is correct, Judge.
Okay.
In any event, he is not currently under any sort of supervision from juvenile court or anything. Obviously, he's 18, so he wouldn't, unless he had something that carried over, but that is not the case. So in any event, Your Honor, one thing about this case that really does stand out to me, you can see Mr. Anfield is young. He's a relatively small person. One of his first nights at the jail, his mom contacted me, and she was basically frantic because she said somebody had sent her an Instagram video from inside the jail of another inmate beating up her son. And she sent me that Instagram video. I have it on my phone, and it's an extremely difficult thing to watch, Your Honor. And I'm not here to, condemn or to call into question what happens at the jail. I know that there's an impossible task that's been assigned to the people at the jail, and limited resources, and that sometimes things happen. But he has been a target since he's been at the jail. He has had, unfortunately, not numerous, but a few people who have really come after him individually. And he was beaten pretty badly when he was at the jail.
Do you have a theory for that? Is it because he's young or small, or because he's in gang X and those guys are in gang Y, or everyone knows the deceased and so they're looking out for the deceased?
No, I don't think it has anything to do with the deceased. It has to do with the fact that quite often, in all honesty, Judge, if other inmates know that you have an attorney that your family has retained, the inmates assume that you have money and
put on their books.
Put on there, and that's exactly what's been demanded of Mr. Anfield, that his parents put money on the books of other inmates and such. So, Your Honor, what I'm asking you to consider in this case is a total bond in the amount of $50,000, that he be required to live with his mother, Tamara, and I have that address, if you need it, that he wear an ankle monitor, and that he be ordered to stay at home other than to attend school, because he is in his senior year of high school. He's on course to graduate. He's in the time, in other words, he's been on course to graduate from high school. He hasn't been held back. He just turned 18 on November the 19th. So, he's been on course with school. He doesn't work, but that's because he's enrolled in school, and he obviously lives with his family. So, Your Honor, that's what we're asking you to do.
Got it. Mr. Anfield, Skyview High School, is that the high school for the neighborhood where you live, or is that one that you commute to? Or tell me about that. I don't know that high school.
It's on Old National.
But is it is a Fulton County high school?
Yeah, it's like a GED school.
Okay. Is that, if I lived in your neighborhood, is that the high school I'd go to, or you're going there specially?
Yeah, I'm just going there because I'm trying to catch up.
Okay. Had you dropped out of high school before?
No.
No? Well, tell me how you ended up at Skyview as opposed to whatever high school you'd go to that's in your neighborhood.
I was going to Banneker High School. It's in College Park, I think.
Yeah.
I was behind on some classes, and they suggested that I go to Skyview.
Okay, so it wasn't that you got kicked out of Banneker for discipline or something. It was, this might help you do better and get the GED.
Yeah.
Okay.
They said if I go there, I graduate on time.
Got it. And is it an in-person high school, or is it virtual?
In person, but we on computer all day.
But in the high school?
Yeah.
Got it. When you got arrested for this situation, were you living with your mom or your dad or somewhere else?
I was living with my mom.
So you'd be going back to the household you were in when you got arrested for this?
Yeah.
Okay.
All right. And he was actually at home on the day that he got arrested. They actually came to his house.
Okay. Thank you. Mr. Hiles, I know a whole lot less about this because the affidavit says person A shot person B, and that's it.
Yeah.
And so knowing that what you're going to share is simply allegations, sometimes it's more because it's, hey, on his phone was a video of X happening. A little context would be helpful because the context that I've received from Mr. Melnick is we have someone with essentially no criminal history, not hugely unsurprising because of his age, but you and I and Mr. Melnick deal with 18-year-olds who actually have an adult rap sheet, and Mr. Anfield doesn't. So the picture right now is pretty murky for me. And if I have to, as I must, consider the ALA factors, he's got family, they're here, haven't been in trouble. So Mr. Anfield is starting to fit into those slots.
Well,
and you may agree.
Let me address some of those for you.
Okay.
I'm going to start with his juvenile history. So he was adjudicated delinquent by plea under case number 23DL02437. That was a petition that was filed on September 20th of 2023, and the final disposition was on November 15th of 2023. The plea was for a adjudication of delinquency. It was for possession of a handgun by a person under 18 years old, as well as misdemeanor obstruction of law enforcement officer. Judge, I want to speak to the, I know what was said to sheriff's officers in regards to the fights and the attacks on Mr. Anfield, particularly inmate Malachi Hill, who was a YSL member, spotted the defendant immediately upon being placed in the general population and blamed him for some shootings that occurred to YSL households outside. Now, I cannot validate any of that. Those were allegations that were screamed at or directed towards Mr. Anfield in front of other deputies. I don't even have police reports, but that's, and since that has happened, those 4 members who attacked him, who were all YSL, the sheriff has implemented keep separate orders.
But interestingly, Mr. Anfield wasn't jumped by just anyone. It was all from your research, YSL members.
That's my understanding, and that he was, he's a member of a gang called the 2200, which is a blood set that operates in kind of the South Fulton area of the county, as well as in predominantly Clayton County and a little bit in the South Fulton area. Judge, what led us here today was the murder of Mr. Chandler Carter. So to give you some more clarity as to what happened, Mr. Carter was on his way to work at the Amazon facility. Many of those Amazon workers take the MARTA train and then cross over towards Buffington Road for a trail that cuts through some wooded area and directly into the Amazon facility. Another worker who was on his way to work around the same time at that 3 a.m. shift noticed the victim's body lifeless. He shook the victim. When there was no response, 911 was called from a nearby gas station and officers came out. When officers responded, they were informed that most of the Amazon workers and the people who were on that particular trail come from the MARTA station. HD video was obtained from the MARTA stop, which showed 3 at the time unidentified black males follow the deceased victim, and then flock cameras showed them crossing flat shoals towards the area where the victim was found behind the deceased victim. Those 3 images of the 3 individuals that were following the deceased were sent to local police departments. Kenya Manson of City of South Fulton identified Mr. Anfield and recognized him as a member of 220 Gang. 2 Instagram accounts for Mr. Anfield were provided to Union City detectives. Union City detectives then looked at recent postings and taggings from Mr. Anfield to determine the identity of his co-defendant named Rashad West. Officers looked at Rashad West's account and saw a recent posting from a known apartment complex that had an actual number posted to it. Officers responded to that area where they made contact with Rashad West. Upon making contact with Rashad West, Mr. West admitted to officers that he, Mr. Anfield, and another individual that goes by the name of Draco robbed the deceased victim, I guess, on his way to the Amazon facility. Mr. West did state, though, that the shooter in this particular case was Draco, who was later identified as Drake Page. So that is what led us to here. It was my understanding, though, that it was the intent to rob the individual, that the three were following him. And there was a specific firearm that was taken from the victim that was told to the police officers. They said that after he was shot, that was removed from the victim's waist. I don't think they were able to get the rest of his property off of him because they were worried about people responding to the sound of a gunshot. Your Honor, in a quick cursory review of the Instagram returns belonging to Mr. Anfield, he is consistently displaying firearms, consistently reciting lyrics about robbing people while displaying the firearms, and consistently identifying himself with the Bloodset 220 Gang out of that South Fulton and Clayton County area. I do want to say that I always quote OCGA 1511-703 when I am using juvenile adjudications in asking for no bail, but it specifically states that the disposition of child evidence adduced in a hearing in the juvenile court shall not be used in other court proceedings other than proceedings provided for by Code Section 1615-9, 24-4-418, and as well as it may be used in the establishment of bail, plea negotiations, and sentencing in criminal offenses. Specifically noting the 1615-9 and 24-418. Those are also the statutes that allow admittance of juvenile adjudications to specific gang cases, which this is. So, Your Honor, based off of the facts of the case, I do think it is a strong case as it sits now. And though the facts themselves might not be part of bond, the likelihood of conviction and the sentence associated with that conviction goes to likelihood to flee. So I would argue that bond should be denied because he is a risk to flee because of the seriousness of the offenses and the mandated life sentence should he be convicted of either the armed robbery or the homicide. As well as that he is a threat to reoffend based off of his own braggadocious nature on Facebook of what he likes to do, the display of firearms, along with quotes and lyrics that insinuate that he gets his money from spending on other people and or robbing other individuals. So essentially, I'm asking that he's a threat to reoffend. You find he's a threat to the community. He's a threat to flee. And I want to point out one other OCGA 17-6-1 F4, which if you do grant a bond on the gang statute, it states that the bond shall be of an enhanced monetary value solely based on the nature of the gang charge. So that's why I'm asking that the bond be denied. I do believe that the Carter family, at least one representative of the family is on Zoom, and if they would like to speak, I'll direct you to tell them when that's appropriate.
Okay, in just a moment. You used a term with which I'm not familiar. Did you say spinning?
Spinning, yeah. They're bragging about like spinning the block. Like that generally refers to driving around the block of somebody at opposition's territory.
Okay.
Oftentimes shooting up. It's just something that's was common in review of certain videos.
Got it. But your understanding, and everyone's understanding right now is very, very preliminary, is that this was a stranger on stranger offense, that Mr. Carter was not known to any of the three individuals you mentioned?
I don't have anything that would indicate otherwise.
Okay, but that the three individuals who were supposedly involved, Mr. West, Mr. Page, and Mr. Anfield, they all knew each other. Were you alleging that West and Page were also 220 members, or just friends of associates of Mr. Anfield?
I do not have enough. There is some evidence that I think Mr. West is, and I haven't had a chance to talk with the lead detective and or any other gang investigation, so I don't want to insinuate one way or another.
So then why is there a gang charge in this case? If you can't link the other two, then Mr. Anfield, assuming for a moment he was acting in concert with those two non-gang members, what would make these allegations gang related?
Well, when you are on Instagram bragging of robbing other people with your with your gang front and center.
That part I get, but that's not what he's charged with. I'm just curious how, I don't want us to get too far out on the limb of the gang tree. If
whether you get, I think it still enhances the status inside the gang by committing these types of offenses at a minimum, subsection B.
All right. Is Mr. West in custody?
So he might be a juvenile. I got to look at this. I know Mr. West and Mr. Page were both arrested on the same date.
Okay, in connection with this, not for something
In
different.
connection with this, they were
Okay.
arrested in January.
Page is P-A-I-G-E?
I believe it's PAGE.
Page like book. Okay, he was arrested and is in custody. And a judge found probable cause to bind over the charges. And same with Mr. West. Mr. West already has, they found probable cause as to him as well.
I do think that Mr. Anfield is scheduled this week, maybe Friday, for a prelim.
Okay,
I think it's Thursday.
Thursday, sorry.
that's an easy one to answer, but I just want to see where they just haven't had bond hearing yet. They must have asked to do it one had it in front of Judge Leffridge, but perhaps Mr. West asked to defer that until the probable cause hearing. Anyway, and that would mean then that Mr. Page's bond is before Judge Leffridge as well, because they went in at the same time. Okay. Yeah, the 13th is the preliminary hearing. be in front of a new magistrate. They're rotating out. Not new to the job, but new to doing prelims.
Do you know who it is?
Judge Hughes.
Hughes will be doing the prelims?
From now on.
Okay.
Judge Brooks's last day doing prelims is tomorrow. Or today even. I think they rotate tomorrow. And it's Judge Hughes going forward.
I was just curious.
Well, there's your answer.
Yeah.
Your turn to respond.
So Judge, I think that using or arguing that lyrics or what people post online is a specious argument at best. There's certainly no evidence that Mr. Anfield has ever committed what we would consider to be any sort of violent criminal offense in his 18 years. So just the fact that he may listen to lyrics that the DA's office or Mr. Hiles finds to be objectionable does not mean that he's any sort of risk to the community at large. It sounds to me like what the state is largely depending on is the statement of a juvenile in this case, which means that the evidence, I don't know what the evidence really looks like. He otherwise, Your Honor, meets the criteria for bond. In looking at Drake Page, I know that you had indicated that bond was denied for him. Obviously, I was not privy to his bond hearing, but he also, Mr. Page has.
So I want to clarify, I don't think either one of them ended up having a bond hearing. Two things. One, West is not a juvenile. He turned 19 a couple months ago. If West is the one who you are attributing the statements to?
Yes, Your Honor.
Yeah, so not a juvenile. But two, what the docket shows is that they both, Page and West, had bond hearings with Judge Leffridge. They were scheduled for that on January 28th, but there's nothing entered. And so what I'm guessing is because their prelim was right around the corner, sort of like with Mr. Anfield, they say, we'll come back to you, Judge Leffridge. We want to have that prelim first to see what came of it. And they have since not petitioned Judge Leffridge to have a bond hearing.
Got it. In any event, Judge, I think that Mr. Anfield meets all of the criteria for bond. As far as Mr. Hiles' argument with regard to the enhanced monetary aspect of the case, I think $50,000 is a substantial bond for most people to have to post. For going through most bonding companies, that means you have to put up at least $7,500. Oftentimes, they require other collateral such as property. We are asking, or we're submitting, that he will wear an ankle monitor, so that eliminates the argument related to risk of flight. And Mr. Anfield has otherwise, he has strong ties, and I don't believe that his history is anything. What I was going to point out is Mr. Page apparently has a hold from DJJ based on whatever interaction he may have had. You know, I'm not here on his case necessarily, but there is no such hold for Mr. Anfield.
Mm-hmm.
So I would ask that you grant bond accordingly.
Okay. All right. Mr. Anfield. Oh, no, I need to hear from a family member or members of Mr. Carter. So is that someone who's here or is it someone who's online?
I believe they're online, Your Honor.
Okay. So whoever is on behalf of Mr. Carter, if you could turn your camera on and your speaker on, I'd appreciate that. We've got a Omari McKay.
Hi, Judge.
Hey there. Can you tell me who this is?
I'm Shandoria Williams. I'm
Hello.
Chandler Carter's sister.
Hey, Ms. Williams. Thank you for joining us. You said you're Mr. Carter's sister?
Correct.
Okay. What do you want to share with me about bond in this case?
Well, what the family knows right now is that we're missing an individual that was very live and active in our family. These three individuals committed a heinous crime. We as a family do not feel like they should be able to come home. We have emptiness right now, so we all feel like their family should feel the same. I get it, they're mad because their son is being beat in jail, but think about what we're missing at home right now. We don't get to say anything to our brother, our cousins. We're missing him as well. So I feel like he should sit there and think about what they've done. They robbed somebody that's innocent. He was going to work. He was doing what any normal citizen of America would do. And the fact that they took him away and then think that they can come home, I don't think it's right. Our family don't think it's right. And we think that he should sit there and think about it. And if he feels so strongly and so miserable about the position he's in, then go in protective custody. That's how our family feels right now.
All
He
right,
should
Ms.
not be able to come home.
Got it. I appreciate you sharing that. Can you tell me a little bit about Mr. Carter? How old was he?
20.
20. Okay. How long had he been working at Amazon?
He had been there at that point in time 3 months.
Okay. All right.
In August he had just been baptized at church. He wasn't a gang member of the community. He didn't do heinous crimes in the community. He was a great guy. We don't get to have nieces and nephews from him. We don't get to see him anymore. And the fact that he's gone, we don't get none of that. And the fact that this guy, Mr. Anfield, is begging to come home. I don't. If you do grant bond, I don't feel like $50,000 is enough.
Got
at
it.
all. Ankle monitor is not enough at all.
Okay. Ms. Williams, I appreciate you taking time out of your day to represent Mr. Carter's family and sharing this. And I appreciate everything you had to say. There is, as you said, a hole that can't be filled. Mr. Carter is not coming back. And I know your family is grieving. Thank you for
Something has to happen to these gang members. Something has to happen to them. They commit violence in the communities, and it's almost like everybody is scared to do something about it. And at this point, we're tired.
Okay. Thank you, ma'am. Anyone else?
I don't think so.
Okay. Oh. Okay. Mr. Anfield, I was about to address you and I forgot. It's important that I hear from the family and you can understand why they're hurting. You stand before me with a presumption of innocence in your favor. Mr. Melnick was correct in saying these are allegations. Nothing's been proven against you, but the allegations are pretty serious. And there are a couple strands out there that make me a little nervous about setting bond at this time. One is, it sounds like you've gotten mixed up with guns before. You've got the juvenile delinquency where you had a gun and some encounter with law enforcement, and you were at an age then where it was a crime just to have a gun. And that doesn't mean you have a conviction. It's something that happened as a kid, but that's a data point I'm entitled to hear about because it helps me understand a little bit about your trajectory. I also note that I work with people, unsurprisingly, who are in jail all the time. And you are having a different experience in jail than a lot of them. And one of the things that Mr. Hiles shared with me about how you instantly drew the attention of some of the folks there makes me worry a little bit about what you've been up to on the outside. And about your safety on the outside. I know you don't feel particularly safe on the inside. I don't know that it will get a whole lot better on the outside after these charges that have been brought. And then finally, we've heard a little bit about how someone else who may have been involved in these allegations has decided it makes sense to step forward and talk about what went down. And that makes me worry a little bit about how you're connected to these things. And given all that, I'm going to start out with no bond. That's not necessarily a permanent ruling. I need to tell you a couple things. One, if you are not indicted within 90 days of your arrest, so that clock's already been running, you are absolutely entitled to a bond, and Mr. Melnick will get you back in here. My guess is, knowing him, on day 91. To say it's fascinating, Judge, that you said no bond before, but that's not an option anymore because Mr. Anfield has not been indicted. And then I will set a bond that will require you to live with your mom and be on electronic monitoring, et cetera. but I'm going to give the state the window that it is statutorily entitled to see if it can get its ducks in a row and move forward with an indictment. If so, then your case will go to a judge who can again talk about bond, and that'll be Mr. Melnick who's helping you with that. He will know more about the case because by then you will likely have had your preliminary hearing where more will be discussed about these allegations. It won't just be a prosecutor saying, well, I've heard this and I've heard that, but there'll need to be a detective under oath talking about what he or she knows, and your lawyer will be able to ask questions of that person. And if your lawyer is underwhelmed by what he hears, we get back together again. He'll simply say, Judge, I know a little bit more about this case, and we need to think about bond some more because it wasn't quite like what Mr. Hiles shared with me, which is not me saying Mr. Hiles has misled me in any way. He is reacting to police reports and what people are telling him. And your lawyer just doesn't have the benefit of having been able to interact with the officers who've been investigating this. But given the seriousness of the charge and the fact that really this bond puts you back where you were before all this blew up in front of you, I'm gonna keep you where you are with one caveat, and that is I'm happy, Mr. Melnick, and you can talk with Mr. Anfield about this. I'm not interested in having him go to lockdown if he is the one who's being attacked rather than he's attacking someone. But there are other options that we can engage the sheriff with, whether that means going to a different facility. Some may be less good than where he is now, but away from where he is now. You know those ropes much better than Mr. Anfield does. So talk with him about that. And then just shoot an email to Ms. Nelson and me, and Mr. Hiles will be the point person. It may not be his case going forward, but he was here for the bond hearing. And then if I need to reach out to the sheriff to say, I'd like to consider, I won't order it, but consider having Mr. Anfield be in this place instead of that, by all means, I will take care of that.
Okay.
Okay?
I'll speak with his family about that too, Judge.
Good.
Thank you.
All right. Have you been retained for the long haul or just for bond?
Right now, just for bond and prelim, but
Okay.
I've represented family members before, so I expect I'll be around.
Okay, but at a minimum, you're the person with whom I'll be dealing if it anything to do with bond.
Yes, Judge.
Okay, sounds like a plan. Mr. Hiles, anything else?
No, Your Honor.
Mr. Anfield, any questions about anything I said? Nope. Okay, thank you. All right, before we turn to Mr. Mack, I got a couple folks who've been sitting in court for presiding things, and I want to tackle those. Mr. Abrams, which one of you is Mr. Abrams? Hey, Mr. Abrams. It is hard for me to process your request. Yeah, but like you don't even have an idea. I don't want to make all this public, but like no idea. Like talk to me about why we can't get any identification about you.
Airport, fortunately, over the weekend, I had to go through like, this is my second day. I had to go through like TSA like 3 times because I got turned around, and there are certain seconds where you can't go back. So you gotta go all the way back around. It was hectic. It was a hectic week, and I'm just trying to, fight to make sure I can at least have a place to stay. So
Okay.
I can, take care of what I need.
How are you working at TSA?
I'm not working at TSA. I'm not doing TSA.
You went through TSA.
Yes, and when you put all your things in the bucket, I even had to go. Only thing I was actually able to retrieve was my key. But you have to wait until Monday for it to.
So TSA has your ID.
Yeah,
Okay, and it's there?
yes.
Okay. What else do they have of yours?
Online, they have my food stamp card. They got, other cards and stuff.
Okay, do you have a picture of your EBT card?
I have my gateway account. I can pull up my gateway account for you.
Tell me what that is.
It's the portal.
Pardon me?
It's the portal report.
That the EBT works through?
Yes.
Yeah, if you want to pull that up, that will help. And then are you Special Agent Moore?
Yes, sir.
Great, okay. Let me take care of Mr. Abrams and then we'll handle yours. Sorry to keep you waiting.
Can I approach?
Yeah, nope, no. You can give the phone to Deputy Gordon.
Hold on. That's the first time I saw him speak on the beat.
Yeah.
I just planned it.
Yeah, it's good you're here because otherwise you're like, yeah, go ahead.
Sorry.
Agent Moore, are these for the same case? So it's going to be largely the same. I just asked, I'm not going to read it, but it's basically going to be the same affidavit. You're asking for slightly different things.
Same affidavit, two different vehicles, all the same case.
Got it.
The affidavits are essentially.
Good. That'll make it. Oh, I see. Look at that. Okay.
So do you have the actual? Yeah, so you have
Philosophy.
Yes, sir.
All right.
Yeah. Best in philosophy, 2010, actually.
JD,
Yes, sir.
you're a wayward lawyer.
Waiver is the correct word. I did just start, food stamps, I believe, last year, and you'll see that first application. There was a little confusion due to the, due to their communication system. So I had to renew, but nobody told me I had to renew, so that's why you see a new application in February, because I was just waiting to, I guess, receive, the other ones December and January, but I never received that, so that's why I was informed by them that I needed to make a whole new, file a whole new application and things like that. So I am getting that.
Okay.
I still do have my EBT card. I don't have a picture right now, but I'm pretty sure that won't be a problem too.
When are you going to the airport to get all your stuff?
Tomorrow.
And when are you concerned you might not be in your place anymore? Your phone's about to die. Oh, it's going to make it here. I'm just letting you know the battery is very low. What's the timeline with your residence?
The proceeding was a week ago. Into the weekend, I couldn't try to, I guess, appeal. I didn't, on Sunday, and appeal on Sunday court.
Right.
That's why I come today. Because I was a little discouraged, but a friend did encourage me to just.
Oh, but it's due today.
I believe so.
Yeah.
It's 7 days.
It is 7 days. Okay. So this shows that you've applied.
Yes, sir. If you need to, I guess, have previous information, I can see what I can get from DHS. Previous information like that.
Okay.
But I assure you, the information is valid. Extends. And like I said, I would have been able to make the $200 something payment, but again, I just started my new job, and due to I was in a semi accident. I was in a semi accident. Was that in 23? But no. What was that? Yes. At the end of 23, which that made it hard for last year. For me to get a new job, I was trying to, go through therapy and do different things like that. Just trying to even recuperate my body. And I already have, before that, I have a prior.
Are you staying at In-Town Suites?
No, I am not.
Okay. Have you recently been staying at In-Town Suites?
No. Why does it say that?
I'm just asking you what's going on.
No.
Okay.
Taking the regular arthritis, that I was discharged from the Navy for.
Four, 7, 7. Thanks.
if your address is in Marietta, that's
This
the,
is the mailing address of my
oh, that's not the place you're trying to stay in?
No, the address is the place I'm trying to go on 149 Westlake.
That's in Fulton County.
Yes. Westlake Avenue Northwest.
All right, look up one more thing. Did you get word, Mr. Abate, that Jeremiah Oliver was postponed?
Yes, Your Honor.
Okay. So I will sign this. You understand that for your appeal to have teeth, you got to put money in the registry of the court. Okay, that's usually the stumbling block, is that, hey, I didn't have money to pay rent, and then you probably don't have money to put in the registry either. That doesn't mean you can't try to appeal, but a landlord can pursue an immediate writ of possession if you haven't put money in. Even though you are appealing, the landlord could say, but he didn't put any money in the registry of the court. So there's no way I, as a landlord, could be made whole while this is the landlord speaking, goof around on this appeal. So I want to go get the place anyway. So I don't know what the landlord will do, but I just want you to know how this process works.
I was actually, I didn't know how I could, petition for an actual court order, inspection. Because again, no one, even after I, presented the video evidence of mold, active mold, again, and even I mentioned this in the proceeding, they painted over the mold.
It's always a fix. So you would be presenting that kind of information during your appeal if the judge decided that he or she was going to receive new evidence rather than just rely on the evidence that was presented below. But
They never even disagreed with any statement that I made, which is another reason why I was super confused as to why.
Okay.
They couldn't even sign off on.
right, well,
An amount that I can't even provide.
well, you'll want to bring that up with whatever judge gets assigned your appeal. Okay? And go get your ID back from the airport. All right.
Okay.
You're done?
Thank you.
See ya.
Thank you. Have a great day.
You have. It's up there. You ever been to early county before? Sure.
I find it.
I've been down there. There's not much. So it's a truck. Discussion on that. Who's the lawyer? Maybe I go. He's just on. I think it's on a date, maybe.
All right, you ready?
Yes, sir.
Come on up.
Do I need to move that?
Nope. You swear from the contents of your affidavits are true and correct to the best of your belief and knowledge. Excellent. Then you're good to go. So will this likely end up stateside or federal?
The strategy right now is a little bit of a mix.
Yeah, smaller things come to us.
Yes, well, not exactly. We'd like to run free ultimately. And we'll probably
Decide that one.
pretty deal farms here and then ultimately probably federally prosecute, particularly right now with the undocumented folks being important.
Sure.
Attorney's office is interested in
Right.
at least the main guy.
Yeah.
We got a ways to go. I have found it like the best cases when everybody gets involved.
Exactly. Well, you seem to have been tag teaming lots of people in. Appalachian Task Force, got everyone. There you go. Good luck. Be safe. Whoop. See, you weren't being safe.
I almost fallen 3 times this week.
Uh-oh.
Got faded on the stairs with my kid this morning.
Uh-oh.
Thank you, Judge.
Bet. All right. I think all we have left is Mr. Ransom.
Judge McBurney, I had one thing added on to today's presiding count.
Okay.
It was Mr. Drinkard.
Ms. Nelson, is your volume on?
Yes, Judge?
Hey, is Mr. Drinkard ringing a bell for you?
I'll have to have that case number. I don't remember. I remember the name, but I don't.
Me too. What's the case number?
The case number is 24PI 008-746. I had sent an email about it. There was a response that he would be placed on a presiding calendar. It says on Odyssey 310-25 add-on courtroom 8D at 1:30.
I see that.
He has been in jail for 105 days with no bond. He is unindicted.
Huh. Look at that. It says add-on, Jameel Drinkard. You filed a 90-day motion for bond, a 95-day motion for bond, and a 99-day motion for bond.
I take it very seriously.
Good, you should. All right. What say you, Ms. Nelson?
What say me? Probably too many add-ons. We can bring them over tomorrow. I do apologize.
I understand. So Judge, I have prelims all day tomorrow and Wednesday, I believe. Tomorrow is the 11th, so I would it be possible for us to have it around this time tomorrow?
Let me look.
Thank you.
Is this on your radar at all, Mr. Drinkard? It's not your fault if it isn't. Apparently there was supposed to be a calendar that said add-on Drinkard.
I saw that.
You did see it?
I think Ms. Nelson sent it. I tried to
Okay.
read her emails especially.
Me too, but it didn't hit. I have a pretty long list of who all is here and no Drinkard, but that is not. Are you Mr. Dobbs?
I should have stated that, Judge. I apologize. I am George Dobbs for Mr. Jameel Drinkard.
It is not Mr. Dobbs's
I
fault.
don't remember it because the title of his motion was it was hilarious. I liked it.
I
Like the day 99.
always put the day on there so
I'm sure
that if there is a violation, it is clear that I have been constantly waving my hands
I like
nonstop.
it.
Thank you.
You were saying tomorrow at this time?
If that's possible, Judge, if
Yes, is the answer, because we're in the midst of a final plea calendar tomorrow, so it's a 1:30 calendar, and we will add Mr. Drinkard to our 1:30 calendar.
Thank you very, very, very much, Judge. I will be here as quickly as I can after prelims. It may be a bit after 1:30.
Okay.
I will come down and make an announcement come up and make an announcement if necessary.
Okay. Mr. Abate, are you or someone from your office able to make it for the bond hearing? Okay, good. He's entitled to a bond. It would be day 100 or 101, whatever we're at. So it'd just be a question of what does that bond look like?
Okay.
All right?
Thank you, Judge.
Sorry for the misfire.
It's okay, Judge. I understand. There's a lot going on. I appreciate you being willing to put it on for the next day.
Least we could do. Before you go, Ms. Nelson, any reason why we can't have Mr. Drinkard brought over tomorrow with everyone else?
No, there should be no problem, Judge.
Done.
Thank you.
We'll see you, Mr. Dobbs. Thank you.
Thank you, Judge. May I please be excused?
Yeah, I don't have you on. You're free to come or go today.
I will see you tomorrow.
All right. Did we, Mr. Dobbs, I'm sorry, I interrupted you all. Did we already have a bond hearing? And we did.
So yes, he was previously represented by a colleague of mine who has been promoted, so the file got left on my desk.
Okay, I'm just looking at okay. So I denied it, but we are now to the point where we got to set a bond.
Correct, thank you.
All right.
Oh, okay. Let's see.
No.
Oh my God, I'm resolved.
Do you remember this guy? Not Dobbs, Drinkard.
I did.
Someone needs to be ready for this. It's not good that he's not indicted yet.
I'll be ready. I can explain why.
Okay. I'm remembering this guy now. Okay.
Well, yeah, you'll find out.
We'll talk on the record tomorrow. He looked distinctive when I looked at his picture, and then let me look at the commitment order. All right. Now, Mac Ransom, before we bring him out, let me review what we've got here. So, and this is the Early County. This is why you were mentioning Early County. That's right. It's like Blakely or something where he's from. Yeah. Okay. Oh, Blakely, there it is. That's his address. Okay. And you two have spoken, so we're ready to bring him out.
Judge, if you would indulge us, I've got sort of some pre-trial or some comments I'd like to make about the case, given the amount of time he's been in jail.
Before he comes out?
No, when he comes out.
Of course I'll indulge you. You'll be able to talk. Is this something to which he's stipulating, or this is one where we're going to need to reset it for an evidentiary hearing?
Judge, probably have to be reset, but I'm going to ask that he be released pending any further action by this court.
Okay. If we do go forward, we would need witnesses from Early County, I guess.
Yes, Judge.
All right, but I'm sure the DA's office pays travel. Done. All right, let's bring Mr. Ransom out, please.
I've never been to Early County. South, I think.
I went down there one time. Right here. And yes, I know exactly what they mean when they say below the that line now.
The reason I knew is because of the Senate. It is not under jurisdiction.
It's a beautiful courthouse.
It is a really nice courthouse.
They get the nicest ones out there. Please.
I read.
So they were wanting to try to reset it to get witnesses here from Early County. So you got the bad check case, the criminal trespass. What is that about?
Going to I went to my mom yard to the grocery store and so I don't take nothing like that.
And there's a theft charge too.
They didn't charge me for it. They threw it out.
Oh, did they?
Yeah, they didn't charge me for it.
All right, let's get on the record, please. This is 21 SC 180102, State versus Mac Ransom. Hello, Mr. Ransom.
Good afternoon. How you doing?
I'm sad to see you wearing a blue jumpsuit again,
I
but
know.
it's nice to see you, but I wish it was a different setting, like maybe we were meeting at a McDonald's in Blakely, rather than this, but here we are. Mr. Ransom is here with his lawyer, Mr. Melnick. We have Ms. Dilligard for the state. And Mr. Ransom, I signed in December of last year a warrant for your arrest because you allegedly violated your probation again. This time for supposedly getting in trouble in two different ways. In November of 2024, theft by taking and trespass, way down in Early County. And then also in October of 2024, deposit account fraud, bad checks, also in Early County. I say here we are again because in October of 2024, just a few weeks before some of these things happened, I signed an order revoking your probation for 2 months because you had been arrested for something and reinstating you on probation. And you said, thank you, Judge, don't worry, I'm not going to get in trouble again. And here we are. So Mr. Melnick wants to lay some things out. We may get through this today, but if the state is seeking a particularly meaningful revocation, it may be that your lawyer counsels you to have an evidentiary hearing. In other words, the state has to prove this stuff up. Because we can do, one way we do it is a defendant, you would say, yes, I admit these things happened, and we figure out what are the consequences. But the consequences might be steep for you, in which case your lawyer might say, make them prove it. It's their burden, it's not your burden. Before I hear from Mr. Melnick, though, let me hear from Ms. Simpson, who is with probation. How much time remains on Mr. Ransom's sentence?
He has 3 years, 10 months, 21 days.
All right, so there's a lot to work with here, almost 4 years left. Mr. Melnick, what did you want to share before we get down to the, all right, what are we doing? Unless you want to get down to that first.
Just looking to get down to that, Judge.
Okay.
So Judge, we're not inclined to stipulate to the petition. What I'm asking you to do is release Mr. Ransom back to probation. And as I've talked with Ms. Dilligard, that doesn't prevent the court from having a probation revocation hearing. It just means Mr. Ransom doesn't have to wait in jail while that happens. Mr. Ransom is gainfully employed. I know that the last petition alleged that he wasn't reporting, but apparently he reported from the time that he was released in October until the time he got arrested on January the 3rd of this year. Or were you arrested in Early County?
Yes, sir. I stayed down there a week before Fulton County came and got me. And I've been here 2 months and a week here in Fulton.
67 days, you're right.
7 days in Fulton plus the week down in Early County. And it certainly tracks that it would take Fulton County a week to come get him from Early County. That's not an unusual period of time for somebody to wait. So, Your Honor, I have spoken with his employer. He has a job waiting for him to do construction upon his release from custody. The allegations in the petition are, I think, criminal trespass, and I think the theft by taking.
And bad check. So the trespass and theft by taking are one case, the more recent one, November. In October, just a few days after he was here, it was bad checks. So they're not armed robbery, nothing. This case was serious. These allegations were serious.
Yeah.
They were reduced to where we got, but it was nonetheless a felony conviction with an understanding that Mr. Ransom was going to be heading in a different direction.
So, Your Honor, with regard to the bad check case, that did stand out to me in particular, the bad check count on the petition, because the date of the offense that's on the petition is October the 9th of 2024. I think he was released, the revocation order that you signed is October the 8th of 2024. That's when it was filed anyway. I don't know if...
It was signed October 1, but it really depends on when he got out. I can look that up.
So, Your Honor, in order to even get an arrest warrant for writing a bad check, there has to be notice to the defendant that the check had bounced, and there's a grace period. It's been so long since I've done one of these. I think it's at least 10 days. So I don't know how that timeline would even fit. And then beyond that, Your Honor, Mr. Ransom tells me that the theft charge was actually dismissed down in Blakely County. The criminal trespass charge remains. And then I believe that the theft charge or one of the charges was amended to disorderly conduct. And those are the charges. So Judge, he's waited in jail now close to 75 days between the time in Blakely and the time up here. It's an awfully long time for what appear to be relatively minor misdemeanor offenses that I think the state would candidly have a difficult time proving at a probation revocation hearing, given the spatial proximity between where the witnesses are located and where they would have to come, and whether that's a efficient use of the state's time in any event.
Well, if you're concerned about it, you could always waive their physical presence and we could have them zoom in from Early County.
I would not be inclined to do that.
All right, you're not that concerned.
I'm not that concerned.
Okay.
So, Your Honor, with the time that he served, I'm just asking that you release him back to probation, whether that's on bond or just a general order releasing him back to probation. It just, I think the nature of these allegations are such that he shouldn't have to wait in jail, given the amount of time he's already spent in jail, for the state to try to figure out whether they're actually going to prosecute this probation revocation or not. It doesn't prohibit them from prosecuting this probation revocation. It just releases Mr. Ransom. Then if he doesn't show up for court or doesn't report to probation, then they've got all the evidence they need to revoke his probation.
Got it. Ms. Dilligard, anything you want to add?
Yes, Judge, just that we would object to releasing this defendant. The last time we released him back on probation, he committed 2 new offenses. And so it's the state's position that we don't think he should be released and that we're fine with moving forward with an evidentiary hearing and having our resources subpoena the proper parties to come down and prove up those 2 additional cases. And then, like the court has already notated, and I just mentioned, he has a previous revocation in this matter. And as the court also notated, the original case was very serious. He was given probation. He was revoked 1 time, and then not too long later picked up 2 new cases. So that's the state's position. We object to him being released and are fine with moving forward with the evidentiary hearing.
Got it.
Judge, do you remember the facts of this case?
I don't, but I bet if you told me a little bit, then I would remember. I see what the allegations were, and they collapsed down from kidnapping and armed robbery to something less. But Mr. Ransom did plead, has been on probation, and what I don't have to remember, because it's right in front of me, is since he's been on probation, he's failed to report. So I'm not real confident that saying, I'll just put you back on probation, meaning he'll report. And he has not 1 or 2, but 3 arrests in 2024 while he's been on probation. One of the bases for the revocation in October was an arrest in August. Then we have an arrest in October and 1 in November. They may be piddly arrests. They may not amount to much that is meaningful. Maybe the state can't, by a preponderance, prove them up. I've yet to have that happen, but it could happen. But the state wants to move forward with it, and I see why they might want to move forward with it. Mr. Ransom's previous revocation was 60 days. He is at a little over 60 days. I don't see how this revocation would be less than one that was only for a failure to report and an arrest, where we've got 2 more arrests, albeit arrests for what looks like misdemeanors. So, Mr. Ransom, you're going to stay put, but I'm going to ask Ms. Dilligard to make a couple phone calls today or tomorrow to figure out how quickly she could be ready to go for the evidentiary hearing. I don't think it'll be a particularly long hearing. More important, we aren't going to wait a very long time to have that evidentiary hearing. So it's not, hey, I'll see you in 2 months, Mr. Ransom, for the hearing. I'll see you soon for the hearing so that we can get closure on this. And if the state proves it up.
No, I had moved my probation to Blakely.
But the last petition says you didn't report. The last petition in
So no, what you mean
August.
by that?
I'll tell you in just a second. I'm sorry.
Let's take a time out on that conversation, just so I can wrap this up. Just so you understand, Mr. Ransom, if the state proves up one or the other of these allegations, I will have found not just that you were arrested for trespass, theft by step by taking or bad checks, but that you actually committed those offenses. And so I'll be finding that you broke the law while you were on probation. And that's going to result in a revocation that's more than just a couple months. And so in my mind, we are in still a safe space that you're serving the time that is in line with the nature of these allegations. So right now, they're just allegations. The state has the burden to prove them up. You are going to stay where you are unless Ms. Dilligard says, yes, we want to go forward, but we can't do it for 4 weeks. You won't stay here. I will take Mr. Melnick up on his offer and release you from the warrant, but you will still have a pending revocation hearing where you'll have to come back here on your own resources all the way from Blakely. But for now, it'll be on our resources unless we cannot get this revocation hearing scheduled real soon. Okay?
And by real soon, 2 weeks, Judge?
2 weeks-ish. I'm being mindful of what I've got coming up, which is a civil trial week and a criminal trial week. But if those calendars collapse, we can do that. Otherwise, it can be one of the very first things we do when we're done with the criminal trial calendar.
Okay, let me talk to Mr. Ransom.
Okay.
Come on back.
Well, the sockets.
That was a less friendly look. And he does bad checks and trespass and all that stuff.
That's good.
The courthouse does look real nice on the outside.
It's real good.
But I do think he said Dandridge was out.
So if Dandridge please, I get a reward and then I won't have to go the 24th.
You always get rewards when stuff pleads out. The 24th, if Dandridge pleads, what do you have left on there? Pool. You won't have to do pool. So do what you can. There's your reward.
This was where it's staying.
Unless you've already worked Dandridge out, in which case you just cheated me.
No, not yet.
Okay,
I've asked.
right. I'm gonna see the date stamp on the acceptance, and if it's before 3 o'clock on the 10th, then we'll do pool followed by your 4 defendant case, where we still don't have a new lawyer for Bumpus's guy.
I saw that.
The guy's not right. He's ghosted us now.
Yeah.
He was sort of too good to be true. He's like, yeah, I'll take the case. Yeah, Mr. Fortune, Rod, he had a unique first name, Rodriguez, something Fortune.
He's a brand new lawyer too.
Okay, but he could do it.
Yeah, he could easily.
It would be a step up.
So he's comes appropriately dressed every court hearing, so
And he shows up in person.
that was true. Except for y'all today.
Yep.
Well, I'm presiding, so we're on, but you guys will be able to leave once that's over. What's up with the pink? Everything is pink.
Yeah, you should see my office. It's very pink.
That would fit with everything else.
Yeah, it's actually a little too much. I'm regretting all the pink, but I already committed to it, so I have to see it through.
Is it a design thing? Is it a AKA thing? Is it?
AKA thing?
No?
Nope.
No, just that's your color.
Yeah.
Huh?
I'm gonna email Miss Nelson. I'm gonna do a motion to dismiss the Reginald and Bryant with the co-defendant for Mr. Cherry.
Oh, yeah.
So we can actually officially
Close that out. Because he's doing life plus
Yeah,
something.
at the bar.
Okay, great. Thank you for wrapping that up.
I'll do a motion and that way you can go to order. I'll do a proposed order.
Okay.
Is Cherry still here?
Colonel Edwards is like, I am driving him personally to Jackson. It's like, tell me when you signed it. Like, it's signed. It's like, he is out of here. There's like a medevac waiting to get him out of there. Clayton can deal with it themselves. They can fish him out of Jackson. They so underserved us on that case.
I would sue Clayton, that judge, if I could, if I was the family of Mr. whatever his name, Mr. Fortune, whatever his last name was.
Hold on one second. I'll mute this. Oh, yeah. But that doesn't always mean something. Like poor Mr. That guy from drug court who keeps getting in trouble. Well, don't worry about it. You'll be off.
Jerry seemed like a nice guy.
He did.
He killed a lot of people. He was in and one of them was his grandmother. In Jacksonville, Florida, he killed his grandmother, his best friend. And then he fled from Jacksonville and killed 2 people in Clayton County. And then he came to Fulton and almost killed somebody, but they were beautiful. And then
Oh, that's right. The carjacking.
Mr. Carter.
If you're not in the pretty crowd, it can end poorly.
And he got to jail. It was savage. I mean, he stabbed the guy right. The victim was asleep on the floor. Stabs him while he's sleeping. Victim pops up and he just starts.
And it was a big old shank. I mean, you've seen all the shanks. This was not one of these little ones where it's just like 9 inches. Yeah. Like that goes through you.
I saw that. How is he? He's out.
Good.
It was somewhat bad. It was yeah. I get it.
So it is SWAT escorted you got it on. I seen his mom.
For his like initial appearance, or he was coming to court independently?
I don't know what it was for.
Okay.
He's 18, I think, too.
Well, that was like.
I did not think that guy was only 18. Anfield looked, I figured he's 27, like 18.
Did you see the video for the case Judge Carson was trying to hire him? The guy, the defendant just like came out.
Oh, we talking about
that it's bad. I never said they liked it, and it was a pocket knife. He got into jail with it.
Was this Gabe Banks's case?
No, this was
more recently than that.
More recently than that. She tried a trial division case, the stabbing of one of the officers or deputies. At the jail.
He actually worked downtown.
Right, I know where his face.
The chip.
He had the defendant had snuck in a pocket knife, and he motioned for the.
The crazy part about it, they put me on the scanner, and also that scanner didn't even.
Which is crazy.
Yeah.
This happened in the courthouse?
In the jail.
Oh, in the jail.
Waiting in the booking area. Follow. Yeah.
Yeah.
Oh, he called. And I think the deputy opened the door and he just cut out. I figured out what's going on.
So here's why the date on that offense for the bad checks is 2024. Apparently, when he got released from here the last time, that was an open case.
Oh, it caught up to him.
Right.
Okay.
Yeah. So, and then he ended up pleading out to it.
Okay. Yeah. The dates in here are guidelines. I mean, this is, yeah, but it's putting everyone on notice that there's a bad check scenario out there and then a criminal trespass and theft by taking. We're not bound by the date so much as it's a frame of reference.
And then he says the criminal trespass case was dismissed. Okay.
So let's get it set down soon. And if you're able to substantiate that with paperwork, that would be an effort you'd be making on his behalf.
Yeah.
Ms. Dilligard will figure out who the witness is going to be, and it could be when she's her investigator. Do you have an investigator? An investigator calls down and they say, that case has been dismissed. And then we bring them back to say, it's a very different framework now. You did get arrested for these things. And you can stipulate to the fact I don't know why you would challenge the fact that you were arrested, but you have more context to give and we go forward then.
So can we do that by consent? Rather than bringing him back over?
Sure. Well, if you guys agree to a disposition, you still may be a little bit apart because he's had a revocation before and you have your spin on the seriousness of this, and Ms. Dilligard may take a cumulative perspective that you got 2 months before and now you're getting arrested again. So we can make it happen, and it's never going to be a delay getting him over here. We can get him over here within 24 hours notice or have him on, Ms. Nelson's going to fuss at me for saying this, but get him on a Zoom screen. So don't worry if it's not a full out agreement. If it's not a full out agreement, we'll need him to hear what's going on.
Okay.
All right.
I'm gonna see what I can find out about it today.
Okay. Thank you, everyone. Anything else? I don't see any other attorneys who are going to say, hey, and I have a secret add-on calendar. All right, tomorrow, just so we're on the same page, I've got tomorrow, plea and arraignment in the morning and final plea after lunch. We good? Okay. Yeah, we just finished, man. We can have it whenever we want now. It used to be the policy set it for a certain time, but we wanted to free it up because judges like, it's my presiding week. Why can't I put it where I want? Or I've got 12 of them. I don't want to do them all Tuesday morning. Could I do 5 Tuesday morning and others? So now it's when the litigation manager sets it. Oh, there you go. Thank you, Ms. Jackson and Ms. Rivers. We are done for the day.
Thank you. Have a great one, Judge.
All right, you too.
Have a good evening.
We'll get it good.
Okay.
What kind of case is it?
There's an armed robbery over there.